Restrictive covenants. How's it going, guys? Andre Issa here, your friendly neighborhood employment lawyer, and today we're going to be talking about something called restrictive covenant clauses, specifically in the context of employment contracts. But before we do that, guys, a brief legal disclaimer. None of what I'm about to say constitutes legal advice. It's just legal information. If you have any questions or concerns regarding potential restrictive covenants that you may have in your employment contract, you're welcome to contact me or any other lawyer in Ontario. All right, so with that out of the way, let's get right into it. Okay, so I wanted to start off by defining what exactly I mean by a restrictive covenant, specifically in employment contract contexts. So a restrictive covenant would be any type of clause in your employment contract that would prevent a former employee from engaging in certain competitive practices against their former employer. Still confused? That's okay. Let me give you some examples. There are three main types of restrictive covenant clauses. The first one is a non-solicitation clause. So this is a clause that prohibits a former employee from persuading an employer's customers to stop doing business with the employer and to do business with the employee instead. Another type of restrictive covenant is called a non-disclosure clause. This is a clause that seeks to prohibit a former employee from disclosing proprietary interests or secrets, if you will, about the former employer. And lastly, the final main type of restrictive covenant is what is called a non-competition clause. This is a clause that seeks to prohibit a former employee from engaging in a competing business with the former employer. So that's a little bit about the three main types of restrictive covenant clauses in employment contracts. And now you're probably wondering, what exactly is the legality of these clauses? Well, not to give the lawyer answer, but it depends. Historically speaking, the presumption, according to judges, is that restrictive covenants in employment contracts are illegal because it goes against the public interest. This approach was summarized all the way back in 1894 by the House of Lords, where they said, "The public have an interest in every person's carrying on his trade freely, so has the individual. All interference with individual liberty of action in trading and all restraints of trade themselves, if there is nothing more, are contrary to public policy and therefore void. That is the general rule, but there are exceptions. It is sufficient justification if the restriction is reasonable." So in other words, just because the presumption is that these clauses are void, that doesn't necessarily mean that that presumption cannot be rebutted. As that case notes, if a clause is reasonable, then it may be upheld in a court of law in Canada. So, of course, the next question is, what exactly makes a restrictive covenant reasonable? There are four main conditions that a restrictive covenant needs to satisfy in order for it to be considered reasonable. This was summarized in the 1978 case of LC and J.G. Collins Insurance Agencies. This is a Supreme Court of Canada decision, and to summarize the conditions, number one, the covenant protects a real proprietary interest that is worthy of protection, such as trade secrets, confidential business information, or key business connections and customer lists, and is not simply an attempt to restrict healthy competition. Number two, the covenant is reasonable as to geographical and time, considering the specific type of work and the interests involved. Number three, the covenant is reasonably necessary to protect the legitimate interests of the former employer, and no alternative measure that is less restrictive on the former employee could protect the employer's interests. And number four, the covenant is unambiguous such that its scope is clear and understandable. So, As you can probably tell by now, there are a lot of conditions that must be met in order for a clause to be considered reasonable. And if it fails to meet those conditions, then it may be struck down and therefore deemed unenforceable/illegal. Historically speaking, it's also important to note that non-solicitation and non-disclosure clauses tend to be deemed reasonable more often than non-competition clauses. Not only that, but in 2021, Ontario passed a law that effectively bans non-competition clauses in employment contracts for the most part. There are exceptions to that. One exception to that is during the sale of a business, if the seller immediately becomes an employee of the purchaser of the business, then that ban does not apply in that case. Furthermore, the second exception is if the employee in question is an executive, then that ban does not apply to them. However, just because it's not outright banned in those contexts, that doesn't necessarily make it legal. Of course, you would still have to go through the reasonable test that I mentioned prior. So, that's been a little bit about restrictive covenant clauses in Ontario. If you have a restrictive covenant clause and you would like to know if that clause is either outright banned, and if not, is it considered reasonable, you're welcome to contact me and I can review the clause to let you know, in my professional opinion, whether I think it's reasonable or not, and if it's not, what are the appropriate next steps to take. If you guys have made it to the end, thank you so much for watching. This has been Andre Issa, your friendly neighborhood employment lawyer. Until next time, guys.